Thank you. This should be better. Thank you so much for joining us in this session. Uh, as said, we're going to be covering data privacy and policy today. That is kind of hard to say, isn't it? We have four main learning objectives to cover today. First, I'm going to start off talking about legal and ethical issues in the privacy of sensitive data. Second, I'll talk very briefly about the basic privacy and security concepts within the major federal law pertaining to health data, otherwise known as HIPAA, or the Health Insurance Portability and Accountability Act. Then I'm going to hand things off to Dr. Kuhn, who will talk about the different tools available to protect sensitive data. And we'll also talk about describing the elements of compliant computing. Just as a very brief background, so my name is Cason Schmit. I am an assistant professor here at the School of Public Health at Texas A&M University. I'm also a licensed attorney, and previously, prior to academia, I worked with the Centers for Disease Control and Prevention in issues related to health data, particularly how we could use data to promote population health. In terms of my research, I work a lot on legal issues pertaining to data protection, privacy, confidentiality, security. And I focus a lot on legal and ethical issues associated with using data to promote population health. I am joined today by Dr. Kuhn, Dr. Hye-Chung, who I am very honored to be a part of this webinar with, who has a world of experience working with very, very large, very, very complex data sets in this space called population informatics. She has a wealth of experience working with very complex and very large data sets, and she has a wealth of experience in using technical tools and developing technical tools to assist in protecting privacy, confidentiality, and security of information so that we can use it for socially beneficial purposes. Very, very much looking forward to her comments at the end of my part here. So to start off, let's talk about legal and ethical issues of privacy and sensitive data. Now, before I dive deep into the issues, often there are these interrelated and often confused legal concepts that I like to disentangle whenever I'm talking about privacy generally. Because sometimes when we're talking about privacy, really we're talking about something else. We're just using the wrong term. So there are these four terms here that I want to disentangle before we start getting into the meat of the subject, because each is viewed very, very differently in the eyes of the law. So the first thing I want to talk about is privacy. When we're talking about privacy, really what we're talking about is a set of protections against problems related to the collection, use, or disclosure of information, right? And the types of problems we're talking about might be surveillance, might be identification of an individual. They might be the secondary use of data that already exists in one form. They might be the collection of that data to start with, or the disclosure of that data, right? But what's important to keep in mind is that when we're talking about privacy, we're talking about protections that are rights that are held by an individual against those who might collect their information or use their information. They are rights held by the individual. Now, these rights are rooted and they have very specific origins in legal authorities, laws like constitutions or statutes or regulations. And those laws will define what rights exist and how those rights might be exercised. Confidentiality is similar, but very, very different. Confidentiality is a duty or responsibility that is held by a person who receives or controls information about another. And just like privacy, the scope and the bounds and the extent of these duties or responsibilities are going to be found in laws like statutes, regulations, and constitutions. So these duties are going to sometimes apply to people in very specific roles, like doctors, like nurses, health facility employees, lawyers, or researchers. And again, the laws will define what the scope of these duties are. Now, when I think of all of these different types of data protections, I like to think of this analogy of the privacy cookie, right? So if we think about data being this tasty filling here, you can't get it. You can't get this tasty filling in the center of this cookie unless you first address the two sandwich parts of that cookie, the privacy and the confidentiality. These are gonna exist to sort of protect that inner tastiness. And so when you think of data, you always have to think of what protections exist first. Now, let's talk about something a little bit different. Let's talk about security. Whereas before, when we're talking about privacy, we're talking about a right that an individual has that's conferred by law. When we're talking about confidentiality, we're talking about a duty that a person or entity has to protect information. When we're talking about security, we're talking about a tool, right? And so with our cookie analogy here, security is the wrapper. It's the wrapper that bounds the privacy and confidentiality and the data. So there are two different perspectives that we can use to think about security. We can think about it as a way to protect an individual's right to the privacy of that information, or we could talk about it as a way to maintain or support someone's duty of confidentiality to protect that information. Now, what's in becoming increasingly tricky is that security is being mandated by law. And in the realm of information technology, where things are moving at a very, very rapid pace, when laws mandate very specific security standards, those can be outdated quite quickly, much faster than the law can adapt to the changing technology. So it can be quite tricky to understand the specific legal requirements on the security of information. The last set of terms I want to address here are authorization and consent. Now, like security, authorization and consent are tools, and they're tools that permit data collection, tools that permit data use or disclosure. Now, what's being increasingly questioned, particularly among privacy scholars, are how meaningful the existing approaches to obtaining authorization and consent are, how meaningful those are as data protections. And context is exceedingly important in this space. So, just the other day I was surfing the internet and I got one of those pop-ups and it says, do you agree to the use of cookies on this website? And I was like, maybe I don't want to let this website see everything that I'm doing, so I'm going to limit my cookies. So I said no. And then I went through the option, and then there was another button there that I almost clicked because it was highlighted and it said accept all cookies. And so the way these things are sometimes structured makes you wonder how effective they really are to protecting an individual's privacy or protecting their information or their intentions to protect their information. More on this later. Like confidentiality and like privacy, many contemporary authorizations or consent forms, they have very specific legal origins. They exist, and the terms in those disclosures can be directly due to specific legal mandates. Some of these can be revocable, some of these can be time limited. Now, the next thing I want to do after sort of disentangling these issues is talk about some very basics of legal protections in the United States. And I want to do this at a basic level without talking about specifics, because there are a lot of different data protection laws in the United States that have some important similarities. So if you understand some of the basics, that can go a long way to navigating what is actually quite a complex legal space. So there are three big questions you need to understand when it comes to a legal data protection. First, what data are protected? Second, what are the general data protection rules? And third, what exceptions to those rules exist? So in the United States, typically the laws only protect identifiable data. So if data has been de-identified, whatever that means, then often it will no longer be subject to those legal data protections. What you also need to be aware of is that different laws might apply to different types of data. So health data are protected by one law, education data might be protected by something entirely different. Video rental data might be protected by a third law. Also, different laws might apply to different controllers or processors of information. So if you are in a different economic sector, you're doing different types of activities, a different law might apply to you. So many US data protection laws will have a general rule. And that general rule for data protection laws is that the collection, disclosure, or use of this identifiable data, because it's usually identifiable, is going to be restricted to certain limited purposes. And there's often a list of what those limited purposes are. Unless, and this is important, an individual authorizes or consents to a collection, disclosure, or use of their data for another purpose. And in this way, laws are putting the control in the hands of the data subject or the consumer. We might think of this, we often consider this a consumer protection model, that the consumer has the power to basically allow their data to be used for any purpose as long as they give their magic authorization or consent. Now, even though we've got this limited list of purposes that we can disclose or collect or use data under the general rule, there are almost always exceptions to this general rule. So these exceptions will typically permit the use of protected information for some other purpose. Usually these are what we might think of socially desirable purposes. And a great example of this is that Hipaa, this law that protects health information that many people think is a very, very strict law, has a lot of these exceptions. And one of them that's going to be really relevant in the biomedical space is that Hipaa permits the use of identifiable data to be used for research under certain conditions, right? So that's a major and really wonderful exception for biomedical research involving secondary data. Now, this slide is one of the reasons I like talking about laws very generally before talking about specifics. What you see here are about 24 different federal data protection laws. Looking at the federal laws, they're probably about 4 times, if not more, this number of laws protecting data. So you can see this is a very complex space. To make it even more complex, this is only the federal. At each and every state, there might be a similar list of laws that provide additional protections to different types of data. This is an incredibly complicated space, which is why I wanted to first provide you that sort of very general overview of what you can expect when dealing with data from different sectors. And the reason why this diversity is important to realize is because the laws in their substance can be quite different. So what you see here are those same roughly 24 laws, and a breakdown of how they go about defining what information is, quote, identifiable. So I want you to eyeball this and just see that there are quite a few differences in the way these laws approach what's identifiable. Now, the other thing I want to point out is here in the far right-hand column, what you see is de-identification standards, right? Some laws have specific legal definitions that can be used to determine whether or not data are legally de-identified. Others do not. And for those that do not, what's really important is how that information is defined in the law. So if it either meets the definition or if it doesn't, it can matter a whole lot whether the law applies. If there are specific de-identification standards, that's another way to maybe take information that's protected and remove all or some of the legal protections associated with that by applying the legal de-identification standards. Now, these different laws are going to have different rules for a number of different, what we might call stops on this health data life cycle. Some laws are going to permit the use of identifiable data for some purposes. And if they provide this or permit health data to be used in identifiable format for some purposes, they might require some additional security protections to be in place. Other laws might define or require specific data retention measures. They might include how long you need to maintain data, whether that data needs to be returned, whether that data needs to be destroyed. Other types of laws might prevent or permit the use of only de-identified data for some purposes. And other legal provisions might completely restrict the data to be used or disclosed for some purposes. The specific law really matters when determining which of these paths the data train goes, or can go, at least legally. Now, as I mentioned previously, many laws have exceptions to their general rules. And what you see here are at least two exceptions that are important with regards to population health. First is the disclosure for public health activities, which you see that is kind of a rare exception in these roughly 24 laws that we have here. Research is quite a bit more frequent, but it's still not a universal exception for many of these different data types. So it's pretty important to be aware of is whether or not there is an exception that allows a specific type of data to be used for a specific purpose. All right. Next, we're going to talk far more specifically than we have been about probably the most important regulatory framework with regard to protecting data in research. And that is the federal common rule. So the federal policy for the protection of human subjects is known as the common rule. And it's called the common rule because it generally describes the common regulations that have been adopted by 20 federal agencies. The FDA, has a highly similar version of it, but it's not quite identical. So we might think of this as 20+1. What you should be aware of is that most all academic institutions follow the common rule. And for those of you who have done biomedical data science work, you know this when, or you've experienced these regulations through your IRBs, or institutional review boards, process to approve your research or request modifications of your research. They are using the common rule regulations to guide those processes. What is really important to realize and to be aware of is, in the context of data science, is that these regulations apply only to research involving human subjects. And in data science, human subjects means identifiable private data. So if it's not identifiable, how that's defined in the law, then the common rule regulations aren't going to apply to that. So let's get far more specific here with our regulations. And I want to take a look at the scope of the common rule. There are two critical definitions in the law for the common rule scope. One is research, and the second is what is a human subject. When we're talking about research in the common rule, we are specifically talking about, and only talking about, a systematic investigation that is designed to develop or contribute to generalizable knowledge. If it isn't that thing, it is not technically research that's subject to the common rule. So case studies, journalist activities, even those might involve lots and lots and lots of data. They aren't technically research on the common rule. Quality improvement is often not subject to the common rule. Public health surveillance is explicitly exempted. Well, not exempted, it's excluded from this definition. This second really important definition to be aware of is this definition of a human subject. And in the context of data science, there are two important aspects of this. One, we're talking about a living individual. And in the context of data science, we're talking about the when an investigator obtains, uses, studies, analyzes, or generates identifiable private information. The other part of this, which has become important in the most recent revisions of the common rule, is that identifiable biospecimens are more expressly brought into the common rule scope. Let's look at these two definitions a little bit more closely. When we're talking about identifiable private information, we're talking about private information where the identity of the subject can be readily ascertained by the investigator associated with this information. So easily determined that this data pertains to this subject, right? Where that subject is an identified individual. And the definition for identifiable biospecimen very, very closely tracks that, right? It's where the identity of the subject from which that biospecimen was pulled may be readily ascertained by the investigator associated with the biospecimen. Oh. Now, some of you who may perhaps worked with biospecimens or worked with identifiable data and are aware that technology is rapidly advancing in this area might be like, well, what does that mean, readily ascertain? Can't we learn a whole lot about an individual with very, very little information? And this idea that there are these innovations and our abilities to new technologies and techniques that can be used to identify an individual from data or a biospecimen is a very real concern of the federal government. And in the most recent 2018 revisions to the federal common rule regulations, the federal government has said that their goal and objective is to adapt these regulations with an evolving understanding of this concept of identifiability, right? While simultaneously encouraging important research, right? And so part of that most recent revision, the federal government has said that it will re-examine the definition of identifiable private information and identifiable biospecimens every couple of years. And as part of this review, one of the things they'll do is they'll create a list of technologies and techniques that can render non-identifiable data or biospecimens identifiable. So one of the possible outcomes from this evolution, legal evolution, is that if researchers use one of these techniques or technologies with non-identifiable data or biospecimens, then they might still be required to either seek consent for that research activity or seek a waiver of consent for that activity to do it. So in this space, one of the technologies that the government has said that it's going to look at first is whole genome sequencing. And for those of you that work with biospecimens, you might ask the question, well, isn't genetic information, aren't biospecimens inherently identifiable through genetic technology? Well, yes. But remember, the legal definition is readily ascertained. And so the government's paying a very close attention to this. And you, as researchers in this space, should be expecting and anticipating that these definitions might change over time. All right, next, I want to talk about very briefly a number of different ethical issues that often occur in data science. One of the most important ones is this is re-identification. One of the reasons we de-identify data is to protect data subjects. We remove their identifiers from their sensitive information as a way to mitigate the risks that they might experience from providing their data for these uses or purposes. And since that's the case, since this de-identification is a protection, re-identification is a significant threat because it takes those same risks that we were trying to remove and piles them right back on. It's a very, very serious issue, and as technology evolves, it's becoming more and more concerning. The other big one, of course, is inappropriate data collection, data disclosure, or data use or reuse. Now, often, in research, we like to think of ourselves as, well-meaning, and we might look at this ethical issue and think, okay, what I'm talking about here is malicious actors, hackers, or somebody who is stealing a laptop from the backseat of my car. But in the eyes of IRB members and in the eyes of patients or the general public, they are becoming increasingly concerned about inappropriate data collection, disclosure, and use by you, the research team. And so it's something that you should take very, very, very seriously. Trust is fragile. And so you want to ensure that you are acting as researchers with the highest ethical standards to make sure that the public still feels confident in sharing their information for research. Another important issue that's becoming increasingly important are the implications of the inferences that can be made from data. If I'm going to be sharing, say, my social media data with a researcher, there are pictures, there are likes, there are dislikes that might come as part of my social media data. But you can also learn through analytics that those likes or online behavior can be associated with, say, health status. Now, I might not be aware that you are going to be drawing those inferences from what I think is relatively benign data, so I might not fully appreciate what I'm consenting to. Additionally, if I'm working as a researcher with a small population and the small population all agrees to use their data for these purposes, but then I learn about these inferences and apply those inferences to populations that might find these activities highly offensive, or were never provided this opportunity to consent, it creates some tension here in ethical space. The next ethical issue that's important to talk about, and Dr. Coombe is going to talk about this in a far more interesting way than I will, is the balance of protecting privacy with the ability to leverage data for beneficial purposes. We can certainly apply greater and greater and greater and greater and greater privacy protections, but those protections also limit our ability to use data for beneficial purposes. Another really important issue, ethical issue, particularly in data science, is transparency. If you are using secondary data, it means that you are using data that you yourself as a researcher weren't there to collect. So you don't have this relationship with the data subjects. You have not provided them with the ability, with transparency about what your intentions are with this. And communicating that and being transparent with your work is pretty important. People don't want to be surprised that their information that they've shared for one purpose is being used for something entirely unexpected. And one of the reasons, and this is related, there are lots of issues with consent in secondary data research. It's very, very difficult for researchers who use secondary data to obtain consent. For one reason, they don't have this relationship with the data subjects. For another thing, the data might have been collected, say, for well before the researcher has even formulated the hypothesis they wish to test, right? And so can you really ask those individuals for informed consent if you haven't thought of the hypothesis yet? Can you ask them consent if you don't know who they are? Say you're working with data that's partially de-identified, where it can be, if you work hard enough, you can figure out who they are, but it would take a really long time to figure out a contact, a phone number, or an address to go out there and seek consent. And if you were to seek their consent, would you get a biased sample who actually provides the consent? There are lots and lots of very difficult issues with consent in secondary data research. And among those issues is whether or not and how you can provide meaningful protections to the data subjects if you are unable to provide or give them the opportunity to decide to be part of that research. And that comes with the decision-making about whether or not it's appropriate to waive some or all of the consent requirements. So when we think about ethics, one of the things that we tend to dwell on a lot, and rightfully so, are the types of harms that individuals can experience when their data has been used, collected, or disclosed in unethical ways. There can be emotional and psychological harms that result from very private information or sensitive information becoming well known. It can cause stress and discomfort. If that information is embarrassing, there might be reputational harms associated with it. There might be social stigma attached to it. And individuals can be discriminated because that data are now out there or used in an inappropriate way. And related to that, if there's discrimination, if there's social stigma, there's reputational harms, there can be very real financial harm associated with that. Beyond just simply the financial impact of this embarrassing information getting out, there could be identity theft, and there could be real malicious financial harm as a result. It's also important to realize that the loss of privacy or confidentiality is in of itself a harm. Now, it's debatable, and reasonable minds may differ on how significant the harm of just merely the loss of privacy or confidentiality is, but it is nonetheless a harm to have one's private information become no longer so. More remote of a harm, but still a very real possibility, are the possibilities of physical harms. So for instance, if a data subject is in an abusive relationship, and the researcher is asking them confidential things, if that were to get out, maybe say the abuser becomes aware of that information, then that data subject could be at risk of certain physical harm. So it's perhaps a more rare, but still a very real type of harm that can result. Next are group harms. When we learn something in research about a small sample, one of the things we like to do is to be able to generalize that knowledge to broader populations. In the realm of data science, it means that if I know or can draw inferences about people like this, then that might affect a larger group. So for example, in one of the readings that has been provided, or that will be linked to somewhere, there is a story of how researchers at Arizona State University began a research project with a Native American tribe that have a Hipaa tribal community about the potential genetic links with a disease that their tribe was really struggling with. And it was initially started off as a very trusting relationship between the researcher and the tribal community. But once these data were collected, they were used for other purposes that went beyond the scope of that initial research. Uses that cause very specific tension with cultural beliefs and group identities that many of the tribal members thought were insulting and damaging to their identity. And so the misuse of these data can have much broader impact than just from the impact on the data subjects themselves. Another very important issue is the issue of consent, right? More and more privacy scholars are questioning whether or not consent is an effective protection for data subjects, right? In particular, in big data analytics or machine learning or artificial intelligence, applications, do data subjects really fully appreciate what they're consenting to? Can lay people fully understand the implications of providing their data for these practices? Then there's the issue about whether consent's possible. If you're getting a secondary data set full of tens of thousands or perhaps millions of individuals, do you have the financial resources to seek consent? Do you have contact information to seek consent? And if not, how do we protect these individuals? How do we give them meaningful protections? And then there's the issue, as I've talked about previously, about will this activity affect those that have not provided consent? Very important considerations. Okay, I want to stop and pause right here. Are there any questions about what we've already talked about? All right, I'm going to pause for just a second more, mostly because I want another drink of water. All right. Wonderful. So we can dive right into the major health regulation that governs, well, health data in the United States. So we're going to start talking about the Hipaa privacy rule. So this is the Health Insurance Portability and Accountability Act, which protects health information held by covered entities, right? And the general rule of this Hipaa privacy rule is that a covered entity can only use or disclose protected health information for limited purposes unless the individual authorizes that use or disclosure. Now, in the context of Hipaa, those limited purposes are disclosures to the individual whose data it is, and disclosures for treatment, payment, or healthcare operations. Now, before we get too far into this, I want to talk about two very important definitions in this general rule. And the first one is, what is this covered entity thing? Hipaa only applies to covered entities. These are healthcare providers, health plans, healthcare clearinghouses, and the business associates of healthcare providers, health plans, healthcare clearinghouses. If you are not one of these things, Hipaa does not apply to you. Now, a very common misconception is, oh, I've got health information, now Hipaa applies to that health information. Well, if you're not a covered entity, then that just isn't true. Hipaa only applies if you are one of these things. Now, there is something called a hybrid entity. This is often a large organization that does some things that are covered and some things that aren't covered. So you might think of a large university. You better believe that the student health services at that large university are providing healthcare services. That is a covered activity, right? But the English department or even the math department, they are not going to be providing these covered services. So what these large organizations can do is call themselves a hybrid entity and draw a line between the components that do these covered things where Hipaa applies and the other parts of the organization where Hipaa doesn't apply. And there are very specific requirements to this. Okay, I see there's a tangential question here. I'm going to get to that towards the end of this section. Promise. Now, in terms of a business associate, there's actually a really long definition for this in the law. But what you should think about is whether or not you are providing services on behalf of a covered entity. So you are helping the covered entity do the things that that covered entity needs to do with its protected health information. The second important thing to understand when determining whether or not HIPAA applies is this definition of protected health information. And we really can't talk about what protected health information is without talking about what individually identifiable health information is. So an individually identifiable health information is information that's created or received by a covered entity. It relates to the health of an individual, and it either identifies the individual or it's reasonable to believe that the information can be used to identify an individual. And this definition is kind of vague, and particularly to many computationally minded data scientists. Well, like, what is reasonable? Like, when I can apply these very sophisticated techniques to re-identify somebody, of course, anything or just about anything is identifiable. And I hear you, I sympathize you. The law is quite vague in this. Fortunately, there are some standards we'll get to later that can help assist with this process. So if you have individually identifiable health information, and it is automatically protected health information if it's transmitted or maintained in any form or medium by this covered entity, right? Now, I think one of the reasons why HIPAA has these de-identification methods is because that definition we just talked about before was a little vague. One of the reasons why we want to de-identify information is because if we can take identifiable information and make it not identifiable information, then the law no longer applies to it. So we have these de-identification standards as a way to make these data more useful outside of the law. And there are two legal ways to do this under HIPAA that have been expressly defined. One is this statistical de-identification, often called an expert opinion method. And from my personal opinion, I think this is a far underused method in the law. And it's where an expert provides statistical manipulation or redaction or somehow messes with the data in such a way that the risk for re-identification is, quote, very small. And this could depend on who is receiving the data, whether they're sophisticated, whether they're a layperson. It may differ. The other is what is known as the safe harbor de-identification method. This is a way overused method to de-identify data. It's often used where it doesn't need to be used. More on that later. But it's a very easy way to de-identify data because all you need to do is exclude, remove, redact a list of 18 types of identifiers from that data. And then as a matter of law, that data is de-identified as long as you have no actual knowledge that somebody could be identified in that data set. The other method that I'll only talk about briefly is if you aggregate data at a sufficient level, then that data is not going to be individually identifiable because it's been aggregated. Now, we've talked about our general rule. We've talked about what data are covered. What you need to know about HIPAA is there are many provisions within HIPAA that allow the use and release of identifiable health information. So if you need data for public health activities, there is a provision that allows the release of identifiable data for those activities. If you need identifiable data for research, there is an exception that allows you to have that identifiable data to research. There are many, many different types of exceptions to this. So it's something that you should be aware of. Okay, there are two different types of disclosures that you can get under HIPAA. One is the minimum necessary disclosure, and the other is a limited data set disclosure. Now, HIPAA allows you to disclose what's called a limited data set for either research, public health activities, or for healthcare operations. And essentially what a limited data set is it's a data set with specific types of identifiers removed. And to get one of these limited data sets for, say, research, you would need to enter into a data use agreement with that covered entity that wants to disclose it. The second type of disclosure is the minimum necessary standard HIPAA disclosure. This is kind of the default disclosure standard under HIPAA. And the general rule here is that you get whatever you need for that activity. So in the context of research, I might be able to get more data elements than, say, I would get from a limited data set because I need them for my research. Now, the only caveat here is that you have to undergo reasonable effort to sort of wean that data down to what is the minimum necessary. It doesn't need to be precise, but you need to take reasonable efforts to ensure that you're not giving away far more than is needed. Now, I include this slide just so you can get a sense of over here, what you see are all the different data types that need to be removed for safe harbor de-identification. And over here are the different types of identifiers that need to be removed for limited data sets. And so what you see here is that they're largely the same. Only the ones down here at the bottom are different. Now, these excluded data down here can matter quite significantly in a given data project, but they still require the redaction or removal quite a bit. All right, wrapping up things right before our break, let's talk very briefly about HIPAA security rule basics. As with the privacy rule, HIPAA security rule only applies to covered entities. If you're not a healthcare provider, health plan, healthcare clearinghouse, or a business associate of those, then HIPAA does not, the security rule does not apply to you. The basic premise of the security rule is that it requires covered entities to implement appropriate administrative, physical, and technical safeguards to ensure the confidentiality, the integrity, and security of protected health information. And there are 4 general requirements that apply to each of these administrative, physical, and technical safeguards, right? There are steps to ensure the confidentiality, integrity, and availability of protected health information. There are steps to protect against threats and hazards to information security and integrity, to protect against restricted disclosures that aren't permitted, and steps to ensure compliance by your workforce. Now, one of the important things to keep in mind with the HIPAA security rule is that it gives covered entities a lot of flexibility to implement any security measure that allows them to reasonably and appropriately follow the standards that are provided by law. So there's quite a bit of flexibility that's built into this. And what that means to you as researchers is that it's really, really, really important that you follow your organization's policies concerning information security. That's going to be the best thing that you can do to ensure that you are doing what you need to do to follow the security rule. It's also important to discuss your projects and your needs with your organization's designated security officer. This is the best way that they can help you prevent red flags from going up when they shouldn't be going up. So I highly recommend that you do that. Okay. want to stop right in here for questions. I think there was one in the chat, so I'm going to get to that now. But then after that, we're going to take a 5-minute break, and then we'll come back and do a brief, 20-minute tutorial walking through some different technical ways that we can protect the privacy of sensitive information and data science research. It's very, very cool. I think you'll like it. But let me take a look at this chat. So it looks like provide more information regarding the NIH genomics special section requirement for genomic data sharing and the rationale behind it. If you have any input about it concerning the discussed topics. That's a little general. Let me try to find some specific information and see if I can answer that more specifically. I don't immediately have the full recall of all of those things off the top of my head. Oh, I just slide through the slides here. But let me try to answer that by the time we get back from break. Any other questions? Okay, so let's go ahead and take a 5-minute break. We'll start back at 2:05.
Hello, can people hear me?
Yes.
I guess as if people can type on the chat box if they are back from break, that would be great. So we have a sense of starting up again. So thank you, Heidi, for responding on the chat. I want to just check and see if other people are back as well. For those of you who are back, if you can use the link in the chat box, that will open up this Google Docs. It's got 3 links on the document, and there are 3 things to try. Maybe some of you during break got curious and started on the first one. It's a very short tutorial of 15 pages on record linkage. And I think given the limited time, this is just to give you a flavor of it. I would just say kind of try to scan through it quickly. We're not going to spend too much time on it, just to get a flavor of what this might be. And then the more important thing is to click on the second link, which is going to give you a screen to try doing things. So that would be nice to just try for a little bit. And then finally, the third link is a Google form where I only have a few questions that you can just type into after you've tried it. So it's 2:06. So we'll be kind of quiet and I'll be here if you have any questions, but if you could just try to click through a few things, spend maybe 5 to 10 minutes doing the first 15 minutes. Then kind of just click around the second link a little bit just to get a feel for what it's like. And then, type in a few, think a little bit and type in a few things in the third link, which is a Google form. Cason, do you mind bringing up the second link now so that people can just see what the second link looks like? Yep. So you'll get something like this where you can kind of move your mouse around, see things moving. And if you click, Cason, if you want to click on something, if you click, something will open up. So try clicking again. Clicking the same thing. Yeah, so that, see, there you go. There you can see the names. If you click, you can see things. But we'll be quiet until 2:20-ish and see if people can give this a try. Yep, so I see I have a question. If you've kind of gotten through the first tutorial, I would say it's fine, actually. If you've just looked through a few and you've got to the names choice panel, it is 2:16, and I know everybody has not gotten much time with the first tutorial. If this is interesting, you can go back to this after the session. I would suggest that everybody now move to the second link, which I have shared on the screen. So you'll get something like this. And the idea here is the choice panel, as somebody asked, which is here. What you're trying to do is say, okay, I have 2 records. Oops, I'm sorry, my screen is not working with me very well. Let me try to get the screen better. Yeah, so you have 2 records, and the idea is looking at the information on the screen, can you determine if these 2 records are the same person or not? If you think they are very high likely the same person, you would click here. If you think they are very highly like a different person, you would click here. If you're not so sure, but probably different, it's here. Very low likely different, low likely same, and maybe same. So that's kind of what you're doing. We're not really collecting answers. What I wanted everyone to do is to try to have this thinking process. So we're just going to look at the first pair here that everybody's seeing. And you can see this is what it means to be private and give privacy. There are two people here. We want to give them full privacy. We're researchers trying to do research, but we need to know if these two records are the same. And so when you're doing a fully private research, this is how difficult it is to do it. As you might all guess, it's hard to know if these are the same people or not when you can't see anything. And so this is an interface where we say, well, it's really hard for me to know this. So why don't I open up the last name? And you can mouse over and you can click. And what happens when you click is you'll get some information. So you see that senior. And you're like, that's just not enough information for me to make a decision. And you can click again, and then you'll see the fact that the last name is the same. So there's a Mitchell senior and a Mitchell without a senior or junior. You also notice here that the date of birth date is different. And you're like, well, different birth date, same last name. These indicate these are the same first name. If you wanted to see it, you can click and you will see this is Nelson Mitchell. But you might see why you don't need to open this, because if like in the second row, you see same first name, same last name. I don't need to know what their name is. They're same first name, same last name. And so what this panel does is lets a researcher see what you need to make a good decision about whether they are the same or not. And right now, all I wanted you to do, so you'll have 5 more minutes to maybe go through the 5 records here and see what you want to do. The other thing I will point out, if you've noticed, there are things moving at the top. Those things moving at the top, whenever you put a mouse somewhere, you'll see some orange going on, right? There's some orange going on. That orange is every time you click and something opens, that orange becomes green. That's the budget you use, the information budget you use to make a decision. So again, if I put my mouse over it, here's the orange. That orange says if I click, you'll see that information, and that's how much it's going to cost me to see that information. So I click, it becomes green. But now I can see more, I can do more. I believe you can click again to get the full information. And so what happens is you're trying to make a good decision. You need to see things, you will open things. The meters on top will tell you how much it costs to open things. And your job is to see if you can make the best choice possible in the choice panel with the least amount of information, but enough to make good decisions. If everybody can just play with this a little bit, 2 more minutes, and then we're going to move to the survey. Okay, Cason, I think if you want to start on your section. While Cason's setting up to start the third section, he's just going to do the first part. I know that probably this activity, you hadn't had too much time to do a lot in it, but it's gotten you thinking. You're thinking of different things. Hold those thoughts. We're going to now talk about a few of the tools. Your hands-on activity should help you think about and understand what we're talking about. At the end of our tool section, we're going to have a little bit of a discussion so that we can combine your experience as well as the tool section. Okay, thank you, Cason. You're muted? Yes.
Yeah. So before I jump into that, I've got an answer for the question in the chat regarding the NIH genomic special section requirement for sharing genomic data. First of all, as a bit of context, there was a policy put out in 2014, and one of the things that policy wanted to do was increase the sharing of genomic data that's produced with NIH-funded grants. And the rationale behind that is the NIH wants the biggest bang for their buck. They want their research to have the biggest impact, and they don't get that biggest impact if researchers are being territorial and protecting the data that the NIH funds them to collect. So that's sort of like the ground impetus for that that policy. Now, the details of that policy, the NIH stated rationale is that they're trying to maximize the benefits of this research by accelerating, by removing impediments to getting this research done, while minimizing the privacy risks associated with it. Now, there are lots of risks associated with it. So they're drawing fine lines, risks that involve linking data, kind of like what you were doing, except imagine connecting those identifiers with an entire genetic sequence. There, are risks associated with knowing intimate details about individuals, etc. Now, there are very detailed rationales for each and every single one of the components of that data sharing policy that are posted on the NIH's website, and I will drop that in the chat right now. Now, before you click on that, let me just say that what you should also be aware of is that currently the NIH is considering revisions on that data sharing policy for genomic data. So they have just concluded seeking input on suggested revisions to this data sharing policy. So the specific rationales for the policy that existed in 2014 are going to be a lot less relevant in the next couple of months. Now, what I would encourage you to do is visit this website, which I'm going to put in the chat too, and pay very close attention for when they put out that final revision to the that data sharing policy. Because one of the things that revision will do is set forth the very specific rationales for that, for any changes to that data sharing policy. Great question, and unfortunately, the answer is things are sort of up in the air because things are going to be changing. So maybe they're going to be increased privacy protections. Maybe they're going to be different ways that the NIH can encourage increased sharing while potentially protecting or while trying to protect the individual's policy or privacy. Sorry. Now, with that ado, moving forward, we're going to talk about tools for protecting sensitive data. I am starting off again. You haven't gotten rid of me, because one of the most important tools that we have to protect data is the IRB review and approval process. And a lot of this is based in the law, those common rule regulations that we talked about just a few moments ago. Again, the purpose of these regulations is to minimize research risks while allowing valuable research to proceed forward. So the IRB's job is to look at the risks and identify whether or not those risks are appropriately small and whether or not additional protections can bring those risks down. So there are IRBs at academic institutions and industry and private businesses like hospitals. There are IRBs in government agencies. And their role is to fundamentally follow these common rule regulations to ensure that the risks are appropriate for research subjects. There are different processes and different outcomes or determinations that might result from an IRB review process. First of all, they can look at your proposed activity and say, this isn't human subjects research. One, because what you're talking about isn't research under the legal definition, or two, you're not talking about human subjects. Say you've got de-identified data, right? The other thing they might do is look at it and say, okay, well, this is human subject research, but guess what? It meets a legal exemption that says that research under these circumstances does not need to follow these regulations. They're exempt from these regulations. The other thing they can do is say, they can look it over and say, this research activity is really minimal risk. And because it's minimal risk, we're going to put it under expedited review and get it approved very quickly. Or they could look at it and say, okay, there are some serious issues and potential risks that we need to look at really closely. So we're going to get the full board to deliberate whether or not this research should proceed or what protections we can put in place to balance out the risks that might be involved. And as a result, of these different types of processes and outcomes, you have different forms and different applications that you might have to submit to your IRB. There could be applications for determination of, hey, I don't think this is human subject research. Let me describe it for you. And those can be pretty brief. There can also be forms that are specifically designed for expedited applications. There are there can be forms that are much more detailed for other types of research. And there are types of forms called delayed onset applications. And these are determinations that are really useful if your research is funded by a grant that requires an IRB approval before those funds are dispersed. So in these circumstances, you can submit a sort of an application that lays out the general framework for your research, but it wouldn't permit you to begin that research until you give the IRB more information. And what this delayed onset does is allows you to obtain those research funds, which might help you develop the rest of the protocol that is needed for the full approval. If your research changes, you need to submit an amendment so that the IRB has a good idea of the research that's being done at their institution. There are applications to facilitate continuing review of ongoing research. There are applications for closeout. Some of these categories about different processes or different, whether it's human subject research, whether it's exempt versus expedited, can be a little tricky. Fortunately, there is some government guidance that helps here. So for example, this is a chart that helps researchers understand how some of the new exemptions that were put in place by the most recent common rule revisions, how those work and how you can determine whether or not they apply to your proposed research project. I'm not going to go over it here, but it's useful and it's in the additional resources. One of the most important roles of the IRB in protecting data in these contexts is decision about whether or not some consent requirements should be waived, or all of the consent requirements should be waived in research. And the reality is, in secondary database research, consent is a significant challenge. But IRBs can waive consent under some conditions. And those common rule requirements for waiving or altering informed consent are right here. The major ones are, it can't be more than minimal risk. And the research can't be practically carried out without this waiver or alteration of consent. And that identifiers are needed. Right, those are the biggest ones. Also relevant here are the waiver alteration will not adversely affect the rights or welfare. These are the most important ones in the data science context. Now, a big thing you should be aware of is that reasonable minds may differ at what qualifies as minimal risk. You might say that there's tons of risk involving privacy and confidentiality information, given how loosey-goosey private businesses are playing with our data and how they're protecting the data or not protecting their data and all the crazy manipulative things they're doing to us. Some IRBs look at that type of activity as this idea of what's experienced in ordinary daily life, right? Other IRB members won't do that. And so sometimes different IRB members will view what's considered minimal risk very, very differently. It's something that can be frustrating to researchers that are looking for some consistency. As mentioned, there are the common rule regulations apply to organizations that are receiving funding, government funding for that research. Private organizations often do not have to follow the common rule regulations if they're not receiving that government support. So what you have here is, and these are provided in additional resources, some examples of studies done in, like, say, Facebook, that, you know, some can look at with skeptical eyes. But without much delay, I want to hand it off again to Hye-Chung as we're going to talk now about other statistical tools.
So Cason, can you confirm you can hear me okay? Can you hear me? Okay. Yes, I was having a little bit of a computer problem, so I hope this is working. So I'll go ahead and talk now about other statistical tools. Am I sharing the right screen with the slides? Okay, great. So I'll talk about other statistical tools that are available. So in addition to the data governance tools, there are data and statistical tools where the core of what you're trying to do here is manipulate the data so that you can reduce the risk of privacy of identifying someone. So this is a figure from previously that Cason shared, where depending on what data you have exactly, there are different levels of risk for different people in the data set of identification. And the goal of these different tools that I'll talk about is to say, can you minimize the risk of identifying a particular person in your data set? So the first tool that I'll talk about is called disclosure limitation tools. And this is specific to when you are done with your research and trying to disseminate your research and share it with the public, whether that be via publications or presentations. You may realize that as you are, when you're putting your results together to share publicly via publications or presentations, you may have results that are very small cell size. So you may end up with a cell that's uniquely about one person. If you report out about that one person, now you start to have risk of privacy go up. So you should be aware of the disclosure limitation restrictions on your data. It usually comes with a sensitive data set that you have. And two very common things you do when you get through this phase is, one is check your cell size when you're making your results table. And if the cell is too small, where the too small threshold may be dependent on your context, 10 is an often accepted threshold, like the census will use that, CMS will use 10. And if your results are about things less than 10 people, then what you can do is suppress that result. Instead of giving the actual results, you may give a star. Another technique that people use is what we call aggregating data. Sometimes things like top coding. So if you have data about people and you're reporting out age groups, you know, the 90s and 100s, you might imagine you're going to have very few people over 100, but you'll have a few in your data set. And so what you can do is, here are the results for people in the 80s, 70s, 60s, but you might have your last cell top coded to say anyone over 90, so that you are only reporting out aggregate data for old people without having it split out. There are papers that show that if you do this, there are consequences in terms of the change in distribution, because that group is now bigger than 10, range of 10. But as we discussed, it's been coming up kind of throughout the slide, when you start to do things to save for privacy, there are costs to that, including when you aggregate data, the reporting out just isn't as precise as it may need to be, but that is the cost of providing that privacy protection, right? Very similarly, if you have things like race categories, you might combine them. So if you have small race categories, you might combine them to an other race category. It's often the case that you'll see papers that talk about white, non-Hispanic, Black, non-Hispanic, Hispanic, and other races. And the reason for that combination is because of the small cell size. That's one thing that if you are in this space, when you're at the phase of reporting out your results, you want to be aware of what are you reporting out? Is there any risk to identification in what you're reporting out? And if that's true, you might do things like cell suppression or aggregating data so that what you're reporting out reduces that and minimizes that risk to privacy for an individual. I'm moving on to a different tool called de-identification tools, and this is a category of things that you do. This is actually on the other end of your research pipeline when you're starting your research. So at the very beginning, you've got your data, and you might do things, different things to de-identify your data, because what that will allow you to do is maybe more freely share your data with more people, maybe use computing facilities that are not compliant because your data is now de-identified. So sometimes in your research, you want to go through the step of de-identifying your data set so that you can broaden your reach with your data set. So here are the different things that you can do if you're trying to make a de-identified data set. The most common is called coding data, or sometimes it's called pseudonymized data. And this is something I think if I explain what it is, you might not know of the technical terms, but when you do surveys and when you do surveys, you attach a random ID, a random unique ID to your study participant, that's coded data. So you're going to drop the direct identifiers like names and social security numbers, and instead you're going to replace that by a pseudonym, the unique study ID. And then if you use that to identify the study participant across different things you're doing, that's usually called coded data. And coded data is de-identified as long as you don't have the ability to go back to using the code to attach the direct identifiers. Another technique that happens is you might be also aggregating indirect identifiers. So again, this is what we talked about, similar to the disclosure limitation methodologies. If you have individual level data, and in your individual level data, you have a unique person who is, of a particular race over 100, then you might be required for that individual level data to erase that uniqueness by aggregating it to a group that says other race or over 90. And it's a similar technique to what we saw in the disclosure limitation, where in disclosure limitation, that's about when you're publishing things, do that aggregation. This is about you have individual level data in that particular cell. Well, it says age, instead of having their exact age of 104, you might have to say over 90. And that's what we're talking about. Moving on, there are also techniques for building synthetic data. And that is about building fake data, but not just like randomly fake things. So there are techniques for building good fake data, so you can do research. And the gist of how that works is you will do some research. So most of these techniques assume that the person de-identifying or using this tool has access to the real data that is not de-identified data. So in the synthetic data model, what happens is you have access to identified real data. You're going to do some analysis that tell you the important distributions or signals in your real data. Then using those distributions, you're going to now make a fake data set that has the same distributions. And then once you have a fake data with the same distributions, the assumption is you can apply the same research questions and get somewhat similar answers. But as you can guess, there are caveats to how correct your answer from synthetic data is. Often synthetic data is used much more for training than it is to actually answer real questions. Although it's a very active research area, people are still trying to figure out, are there ways to make synthetic data that could really be helpful to research while still protecting privacy? Moving on, perturbed data is one that's very similar, but because of the limitations of having synthetic data totally replicate the real thing to answer your real research question, another technique is what they do, what happens here is you start with the real data, but then what you're gonna do is you're gonna perturb your data in key areas that make it so that the risk of identification goes down. So one of these examples is aggregating indirect identifiers. So you start with the real data, you might identify all the unique cells in it, such as people who are 105, and then do things like aggregate data or top code so that it is no longer unique. But other things that you might do are things like if you have a field for date of birth, you might go into that field and give it a fake date of birth. But you want to do this with reason such that when you're answering questions, that the research questions are reasonably accurate. So for example, if we talked about Hipaa and a limited data set, you can't have full dates. Well, the limited data sets can have full dates, but if you want fully de-identified safe harbor data, it can't have full dates. So if your research data set didn't have any direct identifiers, but had a date of birth, then instead of releasing a data set with date of birth, you might calculate age at a certain event, so age at discharge. And so that's what I meant. If you're doing Hipaa, you're looking at your data and you're gonna perturb it or calculate it such that the final thing that you have is considered de-identified data under certain conditions.
the important caveat here is actually, I'm just giving you general techniques you can do when you're trying to de-identify data. The details really matter in terms of what you're doing, what your context is, what is the thing that you need when you're finished with the identification. So if you need durations, that's what you get. If you're randomly perturbing your dates so that you don't have actual dates, if the week of, like, if weekend and weekday is important, you want to make sure you're preserving that 7-day cycle so that the weekends stay as weekends. So de-identification is something that you want to do very carefully, such that the value of the research data is still there when you're done with this process. And the other important thing that I want to mention is that the word de-identification is a very loaded term. It's used by a lot of people to mean a lot of different things. So my suggestion is, it's a simple word that I think most of us think we know what it means. I will say, when I hear the word de-identified, I don't assume I know what this person means. My first question is, what do you mean of the many different meanings of de-identification? So if you're in this space and you are using this word, it's kind of important for you to get on the same page as to what it means for this specific case, because under legal terms, one law might say de-identification means this, another law might say de-identification means that. And so it's just important to realize how loaded that term is. And so that if you actually have to do research in this space, you know how to find your way around it. Okay, before I move on to other tools, I really did want to spend a little time talking about what you lose when you de-identify data. So I had all of you guys try to just do a little bit of a case study to see what does it really mean, not in a theoretical sense. We think privacy is important. We should not be identifying people. I think in philosophy, we all agree, but there's a lot of things that come with that. So especially when you're trying to do research, the more you de-identify your data set, the more you aggregate your data for privacy, you are losing precision in your data, and that has costs. So here are some of the things that you want to think about. Often, and this actually has a lot of intersection with data science, because data science by definition often is not about collecting large data sets, it's about using large existing databases that in new ways that you can answer research questions that wasn't thought of originally. And so this, a lot of data science about secondary use. The more you clean, de-identify, aggregate data for privacy, the less utility there is for secondary use. The more raw and precise your data sets are, the more likely that in the future, some 5 or 10 years ago, later, someone might think of something and they can use that data set to answer the question. If you clean out things for privacy, the utility of the secondary use for that data is limited. And that goes to my second point, in that data science is a very labor-intensive research activity. And so if you continue to blindly go for privacy, your research becomes very inefficient, because you'll spend a lot of time cleaning data, you will turn around, and then you will run into your second question and go, oops, I didn't know I wanted this, but now I want this, except I deleted it or I cleaned it. Now I have to undo this. So it's a lot of inefficiencies if you don't think carefully about what you're doing and why you're doing it. And the third point, again, is about not sufficient precision. So this is one that comes up very often. You lose the value of your data as you increase privacy because you have less information. So one of the best examples for this is HCUP is a multi-state data set that's used a lot for emergency department research. Many years ago, when they released that data set for research, it had county of residence. Over the years, with so much focus on privacy, they have decided that they have a residency of state, and they have now gotten rid of county. So this is about aggregating everybody living in the same state into one category for that state, rather than giving the 200 counties in Texas or 200 plus counties in Texas. Again, what happens, you use the value, you lose the value of that data set, because now you can no longer do analysis that will look at variations by county, which is a very important data set, right? So you want to be thoughtful when you're in this space about why you need to do things, what privacy you are actually gaining, and what utility you are losing as you do this thing. The last point that I want to make is, as you think about using these data sets, the other real harm that this happens on research is the more you clean data, the data is proportionately often biased to exclude more poor people, the disadvantaged people. So the people that are difficult to reach in real survey interviews because they are less, on the surface, they also are less available and their data is less clean in our databases. So if you are cleaning out your databases and deleting people because you're not sure if it's the same person or not, or these people don't have social security numbers, often those people that you're dropping are disproportionately people who are poor that is hard to reach in reality. And so then if you're doing a database study and you're claiming that I have a large database study, this represents the whole population, except I cleaned out everyone I needed to clean out, and they happen to be more disproportionately poor people, then your results will be biased. And so in an odd way, when you go toward privacy, your data sets become more biased toward only keeping the standard data people, which is where the issue comes in. And in addition, lots of health issues relate to looking at social determinants of health. If you want to look at social determinants of health, that requires you integrate data from lots of different sectors. That requires you have identifying information so that you can accurately put the data together. And so when you're trying to go for privacy, what is important is that you understand what you're doing, why you're doing it, and you try to not throw the baby away with the bathwater. Okay, this is the last tool that I want to talk about on differential privacy. It's a very advanced topic, so I don't want to go into too much detail, but I thought I could just give you a flavor of what this looks like. So differential privacy is actually, we'll start with what is it? It's not a data set. It's an algorithm. So in this figure, it's algorithm M. And what is a differential private algorithm is like this. In this figure, the top database is D1, the bottom database is D2. The only difference between the two databases is one record, and that's going to be, we'll just call it Joe's data. So D1 doesn't have Joe's data, and D2 has Joe's data. When you run a differential private algorithm M on the data, that is only one record different, and you get a different answer A and B, you can prove that it's differentially private algorithm when you can't distinguish between A and B. And what this means is you run an analysis and your analysis results are not distinguishable whether there's a person in the data set or not. And that's how you guarantee that the analysis is very private and can uphold strong guarantees on the privacy of individual people. But I think in the interest of time, I'll leave it at this. If you are a very statistically oriented person, differential privacy is one of the most advanced statistical tools for doing things like this. There's still a lot of limitations for practical use because this is a way to think about privacy as a budget constrained problem. But if you have to do multiple analysis, then your strong guarantees start to get lost. So the way differential privacy algorithms works is given a budget, in this case, given 3 analysis, I can guarantee that these results are indistinguishable. Or you say, I need an algorithm that I need 5 queries, and up to 5 queries, I can guarantee that the results are indistinguishable. So what differential privacy literature has done for all of us is to really help us think about and concretely reason about the budget that you need for a private analysis. Okay, I'm going to now move on to technology tools. And technology tools, I think actually many of you should be very familiar with it. I don't know that you would easily associate it with it, but the first technology tool that you have for this is encryption. So if you have sensitive data, please remember encryption, encryption, encryption. Any sensitive data that is in transit, in motion, that means that it's moving between computers, you must encrypt it. There are many encryption tools out there. If you don't have one of the easiest things you can use is 7-zip because it's a free software. And I have a screenshot of how to use it. You want to make sure your password is secure. You want to make sure that it's using the current standard, which currently is AES 256. So you want to be able to do that. Even for data at rest, if you have sensitive data on your computers, these days there are good encryptions for data on your computer. So if you're using a Windows machine, there's the BitLocker. If you're using a Mac, there's the File Vault. You should turn these on if you have sensitive data on your laptop. What this does is if you lose your laptop and somebody picks it up, you will not have disclosed the sensitive data because it's encrypted. And that's why you want to turn these things on. The other keyword here is hashing. So many people confuse hashing with encryption. Encryption is 2-way. You encrypt it with a key. When you're going to use it, you decrypt it. Hash only goes 1 way. There is no decrypting of a hashed thing. There are places where hash is useful, and you should be able to distinguish when you should do which. And then, of course, the second part of the technology tools is access control. So this is all about when you have sensitive data, there are good protocols and permissions for who gets to access what. So in order to do good access control, you have to know who. So on a computer, this is called authentication. I really need to know Cason is Cason so that I can know Cason's the one accessing the sensitive data who has permission. And how you do authentication on a computer is called multi-factor authentication. Everybody these days know what it is. We do two. At our school, we use Duo. You have your password, then you have the thing you hold, which is your phone, right? But if you wanted to do the best authentication, it's multi-factor. This one has up to 3. So it's about something you have, like your phone, something you know, like your password, and something you are, like your biomarker, like your fingerprint or your eye, right? So this is all of this is about use your authentication tools so you can do proper access control. And so later when you're getting an audit, you can say, here is who, and I can guarantee this is who accessed the data. That's the technology things. Now here I am to that little exercise that you did. So I think in the interest of time, I will keep it very short, but I saw the responses from your surveys. I think this exercise is good for you all to think about what it means to have privacy, the cost of having privacy, and to think about starting to balance it and how complicated or how much details you have to have correct in such a way that you have both privacy and utility of your data. So I was thinking that if we had time, we might do a little bit of discussion, but I'll stay behind for those of you who want to talk about it. I think in the interest of time, I'll just kind of leave it at that. But what you want to think about is that privacy is a budget constrained problem. And what you're trying to say is for a given budget that I have, here is the activity I can do, and here's the utility I can get from the data. That's the most important thing about privacy and sensitive data. You can't have all privacy and all utility at once. I think that's the most important thing that you want to stick with. Now, the last part of my talk is actually about compliant computing. And this is about when you're using sensitive data, you want to make sure that you're using a computer that actually meets all the requirements. And I don't know how many of you have experience using compliant computing, but some examples are, they're often called data enclaves. VA has one called Vinci. The federal RDC has one. Our school has one called Vital. All of these, and what the key thing is, I wanted to be able to have everybody understand what compliant computing is. Compliant computing is, of course, secure computing. It's got all the access controls and passwords and everything. But on top of that security, you have a legal layer, data governance layer, where your computing allows for that whole infrastructure. And the infrastructure is more than the hardware. The infrastructure includes the policies and procedures in place so that we can all meet our legal obligations. And so it includes things like documentation of our due diligence, the audits that we do. It includes the documentation of all the trainings that are required that we do, and staying up with these requirements. And so it gets quite complicated. What legal requirements you have for a particular research project is very case dependent. It is very hard for each individual PI researchers to be on top of it, which is why the key to being compliant and using compliant computing correctly is to work with the compliance team. So I have up there the set of people at A&M or anywhere else that you should be talking to. You should be talking to your privacy officer who will help you do a legal review, check things out. You should be talking to your security officer so that the computer that you're using meets all of the security requirements. You should be talking to your IT support so that they can give you the support you need to use that computer. And don't forget, if applicable, and you are human subject research, you also have the IRB team that you have to do. So what you need to know as a researcher is that if you are in this space working with sensitive data, it's not the same as just working with any data set. It's the same as working with any hazardous research material like nuclear energy. You want to be aware of what are the things you need to keep your research safe, and you want to know who you need to work with so that you can do things correctly. And that's the key to compliant computing. What I wanted to say is if you're at A&M and you have sensitive data, I am the director of Vital, which is one of the compliant computings on campus. If you are interested, you can reach out to me and I can have a consult about the specific case you have. The application to use Vital is quite simple. You will just go to our website, vital.tamu.edu. and then you can just fill it out. But this is a compliant computing facility on campus that you can use if you're in this space. So I'm going to end on using sensitive data is a very complicated thing. And what you need to do is this, what we call privacy by design. So I have this picture because this really demonstrates many of us who just use computers and data forget that if you're using sensitive data, it is using hazardous material. And once you realize that what you're doing is working with hazardous material in your research, then you are aware that you need the tools and the safe environment to do your research. And the tools are not just go do one thing. It's actually a combination of data governance, technology, privacy, transparency that you have to put together in such a way that you have a lab where you can do the research that you need in an effective way with having enough privacy as well as enough utility so you can answer your research questions. And so that software that you built, I did that under a PCORI R1-ish methods grant, where I was trying to put all the different components together to build one tool that if you had to do record linkage, that somebody could use it to do that process. Much of the privacy by design is of this flavor where you're going to use a combination of different things to meet that balancing that you have to do. And then the last ending point is, many people forget actually, information privacy is not about just hiding things, encrypting things, making sure that nobody sees it. Because the minute you lock things up, it's not only that the bad people can't access it, neither can you. And so the use of utility is where the problem is. And often, although it's not intuitive, transparency and information accountability is a much more effective way to give you privacy. So it's not about locking everything up, because if you lock everything up, you can't use it. You can't do your research. What it is about is having accountability and transparencies and proper procedures in place so that you can do your research correctly and still be able to get to your results. I think this is the end of our slides. So thank you for your time here. I'm going to end with my motto. Everybody knows privacy is very important, but you have to realize privacy does not come for free. And just like when you're driving in the physical highway, everybody has an accident. And the only way not to have an accident is to never drive on the highway. You can't do that. So then you learn to actually learn the proper policies and procedures and the training so you can drive safely. You try to build tools like airbags and seatbelts so you can stay safe. The digital highway is exactly the same. It's very, very dangerous. There are lots of accidents and data breaches, but there are also a lot of tools that if you are properly trained to use them correctly, that you can minimize the risk of having your accidents and you can do your research safely. Thank you. If anybody has any questions, I will stop sharing at this point. There we go. And you know, if you can turn your mics on, or you can, you know, ask questions over chat.
I want to thank again Professors Kuhn and Schmit for their presentation today, and thank you all for joining us. Just as a reminder, our next session will be on Wednesday, June 1st, with the topic of algorithmic fairness and social ramifications. I know I didn't get that right, but we hope to see you then. Thank you all again.